Yeah.
Our next question comes to us from Derek, and his question has to do with an injury, a football injury in exact. He says, I had a fall at work and it hurt my neck and the back, and he's in serious pain. But he also had a neck injury from football 22 years earlier, but had no problem since then. Will insurance try to say that this is a pre-existing condition and not try to cover it? How do I handle this? Now, Harry, I want to ask you this question because I know you both are personal injury attorneys, but this term pre-existing condition, it seems like a lot of times it's slapped on a lot of things that insurance companies don't want to deal with.
Exactly. If the insurance company can show that you had a pre-existing condition, obviously it lessens the damages that they would have to pay out, because they'll say you're already suffering from a particular condition. So they would always love to be able to say you're already suffering some prior back problem, neck problem, whatever it is. In something like this, you'd have to show, and a lot of people play sports or they have activities when they're younger. It's so far in this particular instance, it was 22 years ago. Going through medical records, you can show basically what your condition was, that it had healed, that it was over with, that you had already, healed from that injury. You weren't suffering any problems from it. And so in this particular instance, it would be a new injury, because this accident would have caused essentially a new injury, not exacerbated, what they call an exacerbation of a pre-existing injury. But there are some gray areas where someone does have an issue going on, and then might have some back issues. They get into an accident and it makes it worse. You can show that through doctor's testimony, medical records, whether or not you're actually suffering and whether or not it was still in existence, or whether or not it had healed and it was a brand new injury. But they will certainly try to do that. You're correct.
Okay. Laurel, any thoughts on that?
No, I agree with that. I think they are going to try whatever they can to not pay a claim. And it's possible that you could be injured and it could aggravate something already there. There's laws in place to protect people from situations like that. So we learn about it in law school. It's one of everybody's favorite rules, but the eggshell skull rule, which basically says you take your plaintiff as you find them. And so if their injury occurs, but yet they already had that crack in the eggshell, then you can still be responsible for the additional injuries.
How far back can medical records go? I mean, in his case, it was 22 years, but so how far back, Harry, can you go? I mean, childhood, maybe? I mean, how far back can you go?
I think it all depends on what the injury that is being claimed. And, for instance, if someone has a condition that they've had on and off their entire life, and they put that issue in their case, they kind of open the door for the other side to ask questions about it. But if it is so far removed and really it can't be connected to the old injury from a new injury, they can't just go back and do a fishing expedition. A lot of times we get into fights and battles about when they want to give us medical authorizations to sign on behalf of the clients. A lot of times we'll limit those, or we'll make an objection saying it's so far out of time that it's not relevant to the case at hand. All they're trying to do is stir the pot and come up with something so they can try to put on a defense.
Okay.
There's really no like right line, I guess is what I'm saying. It all depends on the situation.
Gotcha. Very case specific.